In a sexual assault trial, does the judge commit error by allowing other people to come in and say the defendant attempted to rape them too? To find out, you have to read People versus Who Sinned, but it's 17 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Who Sin. The citation for this case is 2025, New York Slip Opinion 03100, published by the New York Court of Appeals on May 22nd of 2025. The issue in this case is whether prior bad acts, including an attempted sexual assault or a completed sexual assault, can be brought in as evidence in a trial involving a current charge of sexual assault or attempted sexual assault, or whether that should be excluded as a violation of the Molino rule. To understand and appreciate the context of this case, what's helpful to know is that there's a case called People versus Molino, and that case established that the general rule has exceptions. The general rule being that we don't allow, in general, a person's prior bad acts to come in as evidence against them in a current case, because the prior bad acts could convince a jury to find the defendant guilty, either because the defendant's not a good person, or let's say the defendant committed 10 previous robberies, and he's accused of robbery in this case, but there's no evidence about the robbery in this case. The jury may convict the defendant for this robbery because of the previous robberies that were committed by the defendant, allegedly. And what if he's not guilty of this particular robbery? We want the defendant only to be found guilty if he's found guilty beyond a reasonable doubt, if the evidence establishes his guilt beyond a reasonable doubt. There are exceptions to that prohibition on prior bad act testimony, and the exceptions generally are called Molino exceptions. There's a list of general Molino exceptions. Those are, we call them mimic. It's motive, intent, absence of mistake or accident, common plan or scheme, or identity of the person charged. And it's a non-exclusive list. So the mimic, the acronym MIMIC, M-I-M-I-C, is a non-exclusive list. And if a proponent of that kind of evidence wants to admit it, they have to, which is usually the people, they have to show the judge, it's a two-part test. First is they have to identify the non-propensity reason why they want the evidence introduced. And if the judge decides that that's an appropriate non-propensity reason, that's step one, and it's a legal question. And the second question is, once they've identified that non-propensity reason, is the step two is, does the probative value of that evidence outweigh the potential for prejudice? Does the probative value outweigh the potential for prejudice? And it's a discretionary question. If the judge says, yes, it does, then it's allowed in. If it doesn't, then it's not allowed in. And that's to be reviewed for abuse of discretion. Okay. What are the facts in this case? The facts are the defendant here, Hussein, was living in a multi-family. He was living in a house with multi-family of the same family. So like his sister and his sister's family, his wife and his wife's sister's family and another sister's family were all in this one house, all under one roof. And the charged conduct is that allegedly on May 25th, 2017 at 10 a.m., the defendant went into a room with his sister-in-law and allegedly engaged in a rape of the sister-in-law and said during the course of that rape of the sister-in-law, I want to do this to your siblings, to your other sisters. I'm doing that to your other sisters. And ultimately, he's charged with this rape. And during the course of the trial, they bring out the testimony and evidence that the other sisters, that the sisters of the wife, the other sister-in-law, came out and said, he tried to do this to me too. They were both attempted rapes, not completed rapes. And ultimately, the defendant was convicted and appealed and said this was improper. He shouldn't have allowed this to come in. And the defendant's defense in this case was not that nothing happened. His defense was consent. His defense was that the victim of the alleged rape that was charged, it was a consensual sexual encounter, and that once it was discovered by a family member, she claimed it was rape. Ultimately, it goes to the Court of Appeals, and the question is, was that an appropriate use of Molino? Was that an abuse of discretion by the court to allow that prior bad act testimony about these attempted rapes by the other family members? And the ultimate holding from the Court of Appeals is it was fair. It was allowed. Why? In particular, because it's about intent. And because the defendant was conceding essentially the conduct of the crime, that there was sexual intercourse taking place, but his defense was that it was not it was not a rape, was not the intent. It was a consensual experience. The intent of the defendant became the clutch reason, the clutch issue before the jury. And in particular, intent is one of those mimic exceptions under Molino. Motive, intent. Intent is the second one that we usually think of. And because it's a non-propensity purpose, and it would be elucidated in particular by these testimony about the fact that the defendant attempted to rape other members of the family, it would go to show that the intent of his rape of this particular person might be also rape. And so in that ground, it was allowed. And that's the case of People versus Husin. When the conduct is already conceded, if that's the defense, then it's more likely to be permissible to allow such other prior bad act testimony to come in. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.